Good afternoon, everyone. Thank you, everyone, for joining us to discuss college athletics and the current legal landscape. My name is Jeff White, and I'm the Chief Legal Officer of the NJCAA and the Executive Director of the NJCAA-E. That's the esports organization for two-year colleges, and I have to admit, I take every opportunity I can to plug esports, as you can see just over my shoulder there. But today I'm really excited. We have an opportunity to discuss the legal landscape in collegiate athletics, which of course is unlike anything we've ever seen in this space. But what I'm really excited about is we have the opportunity to add a little bit of NJCAA context to all these different issues. As everyone on this call likely already is well aware, everything available in the media is primarily focused on the Autonomy 4 conferences. But again, today we're going to give you some of that NJCAA flavor, which is something I'm really excited about doing. The other piece, and really more importantly, I get the opportunity to share some information and the stage with our partners at Husch Blackwell. Now, before I turn it over to our partners at Husch Blackwell, I wanted to make sure to mention that, as everyone here knows, the NJCAA is working very hard to create value in membership. And one of the ways that we've been able to do that, I believe, is we've really focused on providing risk management solutions to our members that go well beyond athletics. So your partnership and your membership within the NJCAA creates value beyond just athletics. Some of you may know Husch Blackwell is a national law firm. They've got more than 20 offices across the United States. And as I said, talking about value and membership and going beyond athletics, the firm represents clients in major industries, including energy and natural resources, financial services and capital markets, food systems, healthcare, life sciences and education, real estate, development, construction, technology, manufacturing, and transportation. So all of this to say, again, your needs and access to Husch Blackwell are far beyond just athletics and just education. But that said, Husch Blackwell does have a nationally renowned higher education team that assists more than 300 colleges and universities across the nation with students' rights, non-discrimination, accreditation, privacy, program development, regulatory approvals, federal student aid, audit, litigation, and compliance matters. Really excited to be joined today by three attorneys who specialize in college athletics and assist schools with a variety of matters in athletics, including, of course, but not limited to athletic eligibility, independent investigations of coaches' conduct and student athlete safety and well-being, name, image, and likeness, contracts, policies, and procedures. The webinar today is just one of the benefits of the partnership between the NJCAA and Husch Blackwell. Hope to have the opportunity in the future to bring a series of these topics and these webinars to our membership. We'll also highlight other resources the firm is able to provide during our next hour together. But with that, I want to turn it over to my friend and colleague, Jason Montgomery.
Jeff, thank you very much. And I'm excited to kind of finally kick off this NJCAA partnership. We are very excited to work with you and your member institutions and assist them in any way they may need. Let me give just a brief background. So I'm a partner here at Husch Blackwell. I'm joined by my two colleagues, Christina Miner and Taronda Randall. All of us combined form the collegiate sports team here at Husch Blackwell as part of the larger higher education group. And so, as Jeff mentioned, we really specialize in these nuanced issues that schools are dealing with in athletics. Today, more than ever, athletics is the front porch of your colleges, and that applies to NJCAA schools too. And certainly, there are a number of cross issues that you're dealing with In the media, they report it in one way, related, as Jeff said, to NCAA Division I. And what we hope to do is break it down as to why these issues are important for you to track on and what areas you can focus on there at your two-year college. So our agenda today, we're going to talk about three main topics. Name, image, and likeness. You all know and love it, and I'll be able to give some color commentary on what that is looking like these days. We're going to talk about what's been, heavily reported in the news recently, and as recently as Thursday, there was a hearing on the proposed settlement agreement, House versus the NCAA. That's an antitrust case, and you all may be thinking, well, how does that apply to me? And hopefully, I'll shed some light on how it may apply to you and your school. And then finally, another hot topic: student athletes as employees, and that doesn't just apply to the larger schools. It applies to any school, and in fact, any athletics department needs to be aware of where this area of the law could be going and what the context is for evaluating whether someone could be deemed an employee. So to start out as an introduction, name, image, and likeness, what are we really talking about? Really, name, image, and likeness is a fancy term that came to be known of college athletes receiving compensation for their likenesses, but really it's about the right of publicity. There was always a right of publicity, and that's a right for individuals to commercialize their own name, image, and likeness. What you had, though, over time was a strict prohibition on college athletes as a result of NCAA rules from monetizing their name, image, and likeness. Taronda is going to get into how this evolved, but I want you all to think about a few different things. In the context of college athlete name, image, and likeness, right now, there are a number of state laws, over 30 state laws. So first, you as an institution are going to look to what your state is doing and what it says you are required to do with respect to your athletes. Then you're going to want to look at the NJCAA rule, and Jeff will talk about that later. But as a practical effect, as this continues to be a lexicon and a known quantity in college athletics, as an institution, you're going to want to determine, do we need a policy related to how our athletes are commercializing their likeness, whether they're wearing our jerseys at that time, whether they're using our intellectual property, if they're reporting it. All of those things are things you should be thinking about and considering. And then from another practical point, do we as an institution need a release and a formal document that ensures that we're allowed to use our athletes' likenesses for our own purposes when we're promoting games and so forth? And this is going to be important as we discuss the possible transition in the NCAA to allowing schools to directly engage in NIL with their own college athletes. So with that, I'll turn it over to Taronda to give us some background on how we got here.
Sure. So let's talk a little bit about the early antitrust attacks. So we're going to start with the O'Bannon case. And that case was litigated from 2009 to 2015. So we're talking about a long battle here. But in this matter, we had Ed O'Bannon, a former UCLA men's basketball athlete who I'm just going to imagine that he was sitting around and he saw himself on the EA Sports game with the jersey, someone that was very much embodying his likeness. And he probably started thinking, wait, I'm not getting paid for that. So Ed O'Bannon became the named plaintiff in this case. And it really was about the NCAA using the name, image, and likeness of student athletes for commercial purposes. Ultimately, this case was resolved in the Ninth Circuit. And the holding led to student athletes being able to be paid cost of attendance. So up until the amount that it costs for them to attend their institution per year. A couple years later, we have the Austin versus NCAA case. And I'm going to pitch it over to Christina to give us a little bit of background regarding that case.
Thanks, Taronda. So in Austin, same trial court as in O'Bannon, but this time the plaintiffs were challenging the restrictions related to education-related compensation. right? So you have O'Bannon, and that's your full cost of attendance, that number online that says this is how much it costs to go to, whatever institution. But what about, education-related expenses? So the result of this case is the NCAA was allowed to limit cash equivalent awards for academic purposes, but not less than the NCAA was permitting student athletes to win for athletic awards. What is very commonly called now the 5980, $5,980. If you added up all of the athletic awards, that's how the judge got to that, where she came up with that number. So I think what's one thing I want to point out is while a lot of folks are focused on this 5980, Alston is 5980, there's actually 4 different buckets of what we term like Alston benefits. So you have your traditional $5,980 of academic awards. Institutions are free to determine what the threshold for that award is. A lot of schools, it was just, if you're eligible, you get that, congratulations. But there were, the other buckets are unlimited payments for vocational schools. There were unlimited payments for postgraduate scholarships at any institution for any former student athlete post-eligibility, wherever in the country for whatever reason. And then you also had unlimited education expenses, computers, other tangible items related to academic pursuits with no real definition as to what that means. So I think a lot of institutions were really focused on the 5980. I personally haven't heard of a lot of institutions going down the route of the other buckets, but all of them are in fact in the NCAA Division I manual. So just kind of a interesting tidbit, as it were.
So
the other piece
Go ahead.
I was going to go into Kavanaugh's concurrence, but go for it.
So what I think I want to point out, which is interesting about O'Bannon and Alston, and why the NJCAA has some interest in this, is this was the first. These were about can a private association limit compensation to athletes? And as everyone knows, the traditional limit to compensation was based on the traditional scholarship, room, board, tuition, fees, and books. So O'Bannon, although it had this component about NIL, it was really about, can NCAA rules limit scholarships to a certain amount? And the court said, no, there's other value that these athletes have and provide to the schools. And so this O'Bannon began, I think, in around 2007 or so, if I'm not mistaken. So you have this progression from 2007. Alston begins in about 2014, and in 2021 is when the Supreme Court comes and says that the NCAA has violated antitrust in limiting education-related benefits. So you had the first time a court said a private association violated antitrust law by limiting compensation. Then you had a second time with the Supreme Court weighing in, and Justice Kavanaugh, again, Alston's not about NIL necessarily, but now I'll tee it up for Christina to talk about Justice Kavanaugh.
So just real quick, on his 3 points in his concurrence. Now, again, as Jason mentioned, the case isn't about NIL, but he's quoted several times in pretty much every lawsuit against the NCAA that has followed that. So his 3 main points were: 1, the court is not addressing the legality of NCAA's remaining compensation rules, and then we'll get to a whole handful of other lawsuits that try to get at that. 2, although the court's not weighing in on NCAA's compensation rules, the NCAA's, the remaining compensation rules, should receive ordinary rule of reason scrutiny. And then under that rule of reason scrutiny, the NCAA has to supply a legally valid pro-competitive justification for any of its remaining compensation rules. And so I think that piece and the pro-competitive justification is kind of where we find the NCAA and their defenses as cases continue.
And just for everyone out there who are video game fans, as Jeff is, O'Bannon is where everyone lost EA Sports games. EA was also named in that case, and the NCAA said, uh-oh, we better not put athletes' likenesses in that stuff anymore. They've now returned, now that NIL is present. So the good news of all these lawsuits is that we have our EA Sports college games back. Football and probably basketball.
So let's talk a little bit more about what led to those changes. So state action is ultimately what moved the needle. In 2019, California became the first state to have a law related to NIL, the Fair Pay to Play Act, if you will. The NCAA, the NAIA, and other associations, they saw the writing on the wall. And so things begin to change. And now we have over 30 states that have NIL related laws. So you may see your own respective state reflected on this particular map. And the laws vary, but a lot of them contain similar components.
Yeah, so I think Toronto overstates that the NCAA was going to change. So one thing I like about having my NJCAA folks here is we can all collectively bash the NCAA, even though some of us used to work there. But basically, when California first passed this Fair Pay to Play Act, which basically said, hey, we think that you should allow athletes to receive compensation from third parties for their likeness, the NCAA said this is an existential threat to college sports. We may not let any California schools participate in championships anymore. And they quickly found out that one of the last great bipartisan issues is we can all agree to hate the NCAA. And so other state legislatures started saying, hey, California, we like what you're doing over here. We want our athletes to benefit too. And then what ended up happening is Florida puts the NCAA on the clock and says, as of July 21st, 2021, we're going to allow our athletes in our state to receive compensation from third parties. The Alston opinion comes out in June of 2021, and the NCAA sees, Justice Kavanaugh says, bad thing to limit compensation. We could get in more trouble. And by the way, just as an aside, antitrust has treble damages, which means they triple the damages that are calculated. And so I wish I would have known that before I chose this path in college athletics, and maybe I would have been an antitrust plaintiff's attorney. But nevertheless, the NCAA then decides, after the NAI had proactively, implemented rules, the NCAA was like one of the last to deregulate their rules related to NIL.
Because California, I think, said that their law wouldn't take effect until 2023, if I'm not mistaken. So yeah. Florida definitely pushed the button with that one. With that being said, I'm going to turn over to Jeff to provide us some more context regarding the NJCAA policy related to NIL.
Yeah, sure. Happy to do that. I will say, there's, you ask legal professionals out there, and there are varying opinions on how California courts and the California legislature, their drafting process, right, and the creativity with which they sometimes use to arrive at the decisions. I will say I was very happy early on. We got pretty engaged in the California rulemaking process for name, image, and likeness, and we were very pleasantly surprised that at the outset there was an exclusion of two-year colleges in that initial draft. And so it gave some semblance of hope, at least at the outset, that there was going to be a clear answer in one state as to how this was all going to apply, within our association. But that, of course, quickly faded. I did also want to point out that when we had the map up there a second ago, I think it's interesting that Alabama is now listed as one of those without a law. And of course, Alabama was actually one that quickly adopted a standard initially, but upon finding that they believed it was a competitive disadvantage to their members, they, I think, are the first and only to have repealed their name, image, and likeness statute. And obviously, Jason, Taronda, Christina, correct me if I'm wrong, but I don't know of another state that has so quickly created one and then repealed it. Are there any others that fall into that category?
No, but it doesn't give you a lot of confidence in lawmaking. I think it was unanimous 48-0 approval of adopting the law and a unanimous repeal. So, to Jeff's point here, interesting thing about these state laws, and they've been amended since to be more pro-institution, pro-local colleges and universities, and anti-NCAA. In fact, going to the extent of explicitly saying in their laws that the NCAA cannot investigate a school in this state. And that has not yet been challenged. The NCAA has other fish to fry right now that we'll talk about here in a minute. But the state laws are very what I guess how would you characterize? They're homer laws. They're
Yeah,
it's
no
the home
question.
team is getting the win. Yeah.
Yeah, and to your point, Jason, I think what happened in Alabama and what we've seen across really the country is it underscores, I think, one of the primary concerns that we've heard about name, image, and likeness, and it's that it really is a recruiting inducement. And so these statutes and processes that have put in place to ensure that name, image, and likeness is not used as a recruiting inducement. There's I guess the thin veneer of legitimacy that's maybe associated with that. But on to the NJCAA's policy. Just so everyone's aware, Article 5, Section 4D3A through C, which, if you don't want to write that down, you can find on pages 24 and 25 of the NJCAA handbook, provide the NJCAA's approach to name, image, and likeness. So as you can see from the first bullet point there on the slide, and what you would confirm if you looked at the bylaw itself, the NJCAA's approach is really recognition that there's a patchwork of solutions. I use that term loosely, solution, throughout the country. So rather than attempting to force every one of our members across the country to comply with a national standard, which of course could potentially conflict with state law, which the NCAA has learned, the NJCAA simply deferred to members to take the steps they deem necessary to comply with state law. Now, having said that, I don't mean to suggest that that this makes things crystal clear for our members, right? I can tell everyone on this call, at least on a weekly basis, we receive an inquiry of some sort asking about what am I supposed to do to comply with name, image, and likeness. I see what the NJCAA's bylaw says, but I don't really understand it. What does that mean? And of course, myself and my staff, we're certainly happy to provide advice and guidance on how best to comply with the state statutes that you may have in place. But again, that's where I would highlight our partnership with Husch Blackwell. If you have questions, concerns, and need guidance on some of these issues, and especially as you start to get really fact specific, our partners at Husch Blackwell are certainly available to assist with those. And when you start getting into those issues, we are looking at building a program or what you have to do, the specific steps that you might have to take on your campus to build a program that complies with your state's name, image, and likeness. Certainly our partners at Husch Blackwell would be available to assist with those sorts of services. Next, you can see the exchange of services requirement there, goods or services. That really ensures there's consideration making this a valid contract. I feel like I'm obligated to make some reference to that. Otherwise, my law school professor that taught me contracts would probably not be pleased. Speaking of that contract review process, for me, I have found it curious that nearly all states require member institutions to determine fair market value. I guess I would ask this of the rest of the folks from Husch Blackwell. Are you familiar with any other higher education type contracts, or really any other contracts where the institution, specifically with students, where they're responsible for determining fair market value? Because I'm not aware of any.
No, I'm not aware of any either. And really, what has come out of this is no one knows what fair market value. Fair market value is what someone's willing to pay for their services.
Right.
And their services can range from legitimate, quote unquote, NIL, which is traditional sponsorship or appearances, to what some folks, as he, Jeff alluded to, is pay for player inducement, which is simply, a minimum amount of work or giving your rights to someone for a significant amount of what amounts to a potential salary. So it is a wide variety, and because they are laws that are tailored to benefit state institutions by state legislatures, there's not an enforcement mechanism in place related to the state laws. And so really you have laws that have not yet been challenged or enforced in any meaningful way, and are on the books to benefit schools against mostly the NCAA and their enforcement infractions process.
Yeah, and Jason, you really just sort of hit upon this with this. There's also the creation of the training and tracking requirements that are placed upon member institutions. And I realize, we've got a lot of folks from our membership on this call, so I'm preaching to the choir here, but you're talking about, in the two-year space, generally speaking, professionals are asked to wear multiple hats. I'm not suggesting that that's necessarily unique to two-year schools, but it certainly is common among two-year schools. And so this idea that there's this dedicated staff, or all this staff that's available to assist with these additional requirements, in my opinion, are really indicia of how little consideration has been given to two-year athletics um, as the legislators are working through all of these different requirements. I mean, the NCAA requires a compliance professional as a condition of membership, and I know the NAIA requires a faculty athletics representative, which is separate and distinct from the athletics department. Neither of those are a reality at two-year colleges, and so again, all of these additional responsibilities and requirements just create additional, I believe, onerous burdens on our member institutions. And I probably should have mentioned this at the outset. One area that I have really started to spend a lot more of my time is really in government relations, and starting to forge relationships not only with state legislators, but with the Fed as well. And so we're taking great steps here at the national office level to ensure that we're advocating on behalf of our members, so that when these questions and conversations come up in the future specific to collegiate athletics, somebody in the room is thinking to ask the question, what about two-year schools? What about two-year student athletes? Because it's been pretty clear to date that hasn't happened. And so that's a challenge. The gauntlet was thrown down from our perspective, and we've accepted that challenge at the national office, and are certainly taking steps to address that. Back to our policy, or our bylaw. The bylaw does also allow agents, as you can see there, in the form of professional service providers, but it's for name, image, and likeness purposes only. So, of course, that's a delicate balance, right? For these agents to only focus on name, image, and likeness, and to never discuss any other form of representation or any other services or possibilities that might be available to student athletes. I'm sure we're all quite confident that that's happening on a regular and routine basis. The prohibited activities listed on the slide are straightforward from the standpoint that they're not just requirements within the NJCAA, but they're generally found in the various state statutes that exist. So there are a lot of commonalities. I think we'd probably all agree across these state statutes. But Jason, I think what I would throw out there is, there's little media coverage on the topic, but NJCAA members find themselves in the same situation frequently, and you hit upon this, as NCAA institutions. And I would just share this one example. The same week, and I forgive me, I forget the young lady's name. It's the pitcher, the softball pitcher from Stanford that transferred to Oklahoma State, and reportedly and allegedly received a $1 million name, image, and likeness deal that was not a recruiting inducement. I want to make sure to throw that out there. The NJCAA national office, we learned of a name, image, and of an NIL deal at a member institution where the benefit was essentially the payment of a cell phone bill. So I'm not sharing this here because there was a violation of any sort. Rather, I'm sharing this because the student athlete at our institution was a Pell eligible student, and the impact of this deal was pretty significant. I mean, it was roughly $50 a month, or whatever, $50 to $75 a month. But I share it because it was just a really interesting juxtaposition of the two types of deals that are out there. And of course, it's really easy to gloss over the $50 deal in the context of the $1 million. And I'm not here to tell you that, I mean, financially, obviously that's a huge gap, but explain to that Pell student that $50 of that cell phone bill is not meaningful. That was a very meaningful opportunity for her. And of course, if and when the House settlement is accepted, everything that I've mentioned above related or specific to the NJCAA bylaw may completely change again. So we'll continue to see how this plays out. But again, I think the most salient message I want to give to anyone from our membership on this call is that we are keenly aware and plugged into what's happening with this and taking steps to stay on top of it.
And before I get to the introduction to the House settlement, I would note that you're like, well, how is that not an inducement? Where's the NCAA at and all of this? Well, there actually is a current injunction that's enjoining the NCAA from enforcing rules related to third-party interactions with athletes for NIL. So it happened in the state of Tennessee. It was the Tennessee Attorney General and the Attorney General in Virginia that together brought an antitrust claim against the NCAA, and ultimately were successful in enjoining the NCAA from enforcing some rules that would, I think the underlying message is the NCAA was trying to enforce a rule against the University of Tennessee, and ultimately the state district court, the federal district court, sided with the state attorney general who was supporting the local institution. So you have more of this support from political appointees and legislatures against this national office, in part because folks have lost faith that they can actually regulate this industry.
Hey, Jason, if I could ask just your thoughts,
yeah.
What are your thoughts on a national association creating any sort of bylaw that is in any way limiting what states currently authorize specific to collectives? In other words, do you think it would make sense for an association to say, we're going to ban the use of collectives? How well do you think that'd go over?
Yeah, we're going to talk. Actually, we'll talk a little bit about how well it went over to the court and House. So I think we're in a position where any association that has any potential market power, right? So you have to have some influence in the market. Limiting compensation to athletes is going to be seen negatively and likely subject you to antitrust claims.
My thoughts exactly.
Yeah. And so House now, the current case that Toronto will give a background on is really, this is about the fact that once you have one law or rule that is deemed to violate antitrust, so we talked about O'Bannon, we talked about Alston, and then there was this opportunity for athletes to get NIL, and folks said, holy smokes, there is a market for this at the highest level for sure, and even at lower levels. And as a result, plaintiff's attorney said, we think that athletes should have been receiving this amount of money earlier. And they brought an antitrust claim related to that, related to television rights, and also related to pay for play scholarship, the ability to actually get paid directly for pay.
Well, thank you, Jason. I'm going to give a quick overview of the cases, House, Hubbard, and Carter, because I think we're a little bit over half our time. We still have a bunch of content that I want to hear Jason and Jeff discuss a little bit more. So with the House case, it was filed in 2020 by a former Arizona State swimmer, Grant House, as well as a women's basketball student athlete, Sedona Prince, who had played at Texas, Oregon, as well as TCU. And that ended up being combined with a filing from a University of Illinois football student athlete. And it sought damages for student athletes who did not benefit from NIL before the legislative change. So they didn't have the chance to really capture benefit from their NIL. Then you have the Hubbard case, which was brought by Chuba Hubbard and a former Auburn women's track and field student athlete, Kiera McCarroll, and that sought damages for student athletes who would have qualified for those Austin benefits that Christina mentioned, but for, they missed out from a timing perspective. And then you have the Carter case, which was brought by a Duke football student athlete, a Stanford soccer student athlete, as well as Sedona Prince. And it was a full frontal assault on just the idea of amateurism and seeking those monetary damages, if you will. So the settlement ultimately has to be approved by Judge Wilkin, who is the same judge who heard the O'Bannon case as well as the Austin case. And the long form settlement terms were filed late July, July 26th. The preliminary approval hearing was just last week, September 5th. And at the end of that hearing, Judge Wilkin declined the rule and sent the parties back to the drawing board, if you will. And I'm going to turn it over to Jason to talk a little bit more about the key takeaways from the proposed settlement as well as the impact.
Well, the first takeaway is that I guess the NCAA overestimated their ability to, within this settlement agreement, legislate against NIL opportunities. And so to Jeff's point, part of this settlement agreement was about, and I'll talk about it in a minute, was about not only institutional involvement in NIL, but some ability to limit collectives and third parties' involvement with athletes. And the judge was very skeptical about approving that as part of a settlement, especially because this settlement agreement is contemplated to essentially have a 10-year lifespan. So let me just kind of give a big picture here of what's going on. So I told you that, people have lost faith in the NCAA and so forth. And in fairness, they are, a big target for significant litigation because of the amount of revenue that's being generated. But this settlement has two components. One is damages related to broadcast right NIL, which is basically this concept that athletes should have been able to share in the revenue of the television contracts, right? So that's one piece. The injunctive relief piece is the effort by the NCAA to say, here's how we're going to regulate ourselves and stabilize college athletics for at least a 10-year period. And we're going to do that in a few different ways. We're going to try to limit additional scrutiny on us by eliminating scholarship limits in favor of roster limits, where you have the opportunity to provide equivalency scholarships for anyone on a roster. So you change the concept there, and you're no longer necessarily limiting compensation. You're limiting roster sizes for a purpose related to the sport. So that's one thing they're doing. The other biggest component of this is a revenue share of essentially $21 million or so. It's 22% of several different revenue categories that are identified, that schools can then use that money to either fund institutional NIL or just provide the additional benefits to their athletes. Now, the trick in all of this, and this is where it's really interesting to look at this as someone in this field, is the trick is that the NCAA maintains jurisdiction and authority over everything else. So over all of the other rules, over progress toward degree in academics, over setting your seasons of competition, over even the recruiting issues that you see in the media, and you're like, how is that an issue if someone's getting paid millions of dollars? Well, the NCAA still needs to have some authority. So the trick in this, and the devil in the details, is although they're agreeing to scholarship or to share in revenue, the NCAA is trying to maintain some level of national presence and authority, and at the same time saying that with respect to NIL in particular, we can have a separate enforcement and arbitration process to deal with discipline in that area, and we can set rules in that area. And one of those rules is essentially that that there's going to be direct reporting of any contracts over $600, and that they're going to limit the involvement potentially of these collectives or boosters paying money to athletes. And that's where the judge stepped in and was concerned of creating additional limitations. I think maybe her quote that was in several media outlets was, "You have to be careful. You know, people don't like to have things taken away from them when they've seen the benefit of it." And so it really is an interesting concept here, and a way for college athletics to potentially move forward from, like, you know, NJCAA, you guys are on the call. You're like, why is, you know, what does this matter to me? Well, I do think that if this comes into play, obviously several, you know, many of your athletes are going to be subject to potential revenue sharing agreements with their four-year institutions as they move on to a four-year school. It's also going to be interesting from the NJCAA's perspective, having athletes who may initially share in some revenue or get paid some amount of money, then go to an NJCAA institution. It's very common that athletes might start out at a Division I or Division II school and then come to an NJCAA school and then move on to finalize their degree. And if they initially do so receiving some sort of level of what is essentially compensation, how does that affect their ability to, you know, to participate at the NJCAA level? It will, you know, probably necessitate a reevaluation of, you know, status and who is eligible at that level.
Yeah, thank you for sharing that, Jason. That's spot on. And I know, you know, while the NJCAA, to your point, is not specifically named in either of these, in any of these lawsuits, and the settlement has really no direct impact on our membership. To your point, it's going to affect our student athletes, which means it's something that we certainly need to be mindful of. And my understanding was, and I realize that the irony with those settlement negotiations is they were technically confidential, yet we're all pretty well aware of what the details are. But my understanding was that at the same time that 10-year injunction was in place, there was going to be strong efforts to seek the Fed to step in to create some sort of national standard surrounding all of these topics and issues, which again, I go back to the point that I made earlier about our efforts to really create more awareness from a government relations standpoint. And so again, just to, I guess, underscore that point with the folks on the call, our purposes in those endeavors are not necessarily specific to any one issue, policy, or cause, if you will, as much as it's just awareness of our association. And so I guess I would throw this out to all of you on this call, and those of you that end up listening to the recording or watching the recording. If you have an opportunity to speak with local and state legislators on these topics, please do. Please create greater awareness, because that's what we found is that the number one issue that we have, and with all of these topics, is just a lack of awareness and understanding that the decisions that they're seeing play out and the issues that are playing out nationally are in fact affecting our member institutions and our student athletes.
This is just another general summary of what's going on in this particular right. One other interesting thing, and I may have mentioned this, but the settlement is set to be for $2.5 billion with a B. A majority of that settlement is going to go towards men's football and basketball athletes. And this raises the specter and question about the application of Title IX. And Tron, you can flip to the next page. And so that's really the elephant in the room. And it's one thing from a damages standpoint to provide relief. It's another thing for institutions to share money at different levels with different teams based upon gender. It certainly requires an evaluation of Title IX and whether there's application in Title IX to benefits beyond the traditional scholarship or education related benefits. And so that has been an ongoing point of discussion as well. For those of you at the NJCAA, if you do have athletes that receive NIL, I think that there hasn't been a lot of guidance or enforcement on this from the Office of Civil Rights. There's one case currently pending in the state of Oregon where there's a discussion of NIL being unequal between teams. And the question will be, how involved is the institution? And traditionally, if it was a third party that is providing the benefit, it would not necessarily result in any sort of Title IX scrutiny for the institution. However, if the institution is more involved with an entity that's providing NIL, so think of booster clubs or collectives, then it could potentially implicate Title IX in some way.
Yeah, this of course says nothing. Of course, it's this athletics component and the name, image, and likeness component to the Title IX regs that dropped in on August 1st, right? And the impending or pending, however you want to phrase it, athletic specific regulations that are in theory coming at some point. And so we could of course spend a whole nother hour or two on that topic and on whether or not you're in a state that has to comply with the 2024 and the 2020, or just one, or however that plays out.
Yes, I try to stay away from those actual regulations because they're too complicated and they change every 4 years. So, yes. But yes, that's right, completely different.
Well, just to jump in and add some more complications to this entire debacle. So this isn't just, House Harper Carter plaintiffs versus the NCAA. There's some opposition to what was impending approval of whatever the settlement agreement is going to look like. The plaintiffs in Fontenot, Cornelio, and Cho, which we're talking about in a second, are all not in favor of the settlement agreement terms as they were last week. Essentially, their stance is that, to Jason's point, that the majority of compensation is being directed to football and men's basketball players, and it continues to deprive women student athletes of, rightful compensation. And there's still, a significant number of individuals that are still saying that student athletes are entitled to, fair wages, and which we'll get to in a little bit. But just as a quick refresher, so Fontenot class action suit on behalf of Power 5 full scholarship football, men's and women's basketball student athletes, of course, Notre Dame football, challenging the NCAA's general prohibition on direct compensation to student athletes. And now, while this case remains open, student athletes have the opportunity to opt out of the House settlement whenever we get to that point, and choose continue litigating this antitrust case as a member of the Fontenot class. Next one.
Which just as a practical matter, like, how complicated is all this? I barely understand it. I went to law school. I've been practicing for 20 years, and we're expecting 18 to 22-year-olds to make informed decisions as to what's going on here. And it does scream for some sort of intervention at a national level, and hopefully that'll happen at some point.
Yeah, it's probably also worth mentioning that Notre Dame was included on that slide because they are actually they were named in that, and not as a result of their game over the past weekend.
I was waiting for that.
Anytime an Ohio State guy can take a shot at Notre Dame.
The second case that I want to talk about, this one is new-ish, relatively speaking. So a former baseball student athlete filed a class action suit on behalf of partial scholarship student athletes, alleging the NCAA's scholarship limits violated antitrust. And so Cornelio, former TCU baseball student athlete, actually got drafted in 2022 and is coming back. There's a theme here of we won a lawsuit and now we're coming back for, but for whatever NCAA rule. Now we're suing again. Plaintiffs were seeking elimination of scholarship limits and then damages for lost scholarship funds there. Did not forget about Cho. It's not new. So Cho versus Brown and the Ivy League class action suit there, claiming that the Ivy League's restriction on athletic scholarships as a whole, the violation of antitrust. So you've got Fontenot on behalf of full scholarship or headcount student athletes. Then you've got Cornelio on behalf of partial scholarship student athletes. And then you've got the Ivy League that doesn't allow scholarships at all. So there is a full circle group that are not particularly happy with where we're going on this one.
The bottom line is, if one attorney can figure out how to sue the NCAA, then a lot of attorneys can figure out how to sue the NCAA.
Yeah, Jason, I meant to mention this earlier when we were talking about the violation of Title IX. I thought I read that yesterday South Dakota joined the fray in filing lawsuits against the NCAA, but this one is specific to the House settlement itself. And one of the areas that they, of course, mentioned was the inequitable distribution. But interestingly, they also brought up the notion of breaching its contract with its members and its fiduciary duty, which admittedly, I don't work at the NCAA, so I haven't spent a lot of time delving in to their issues, but that is the first time I've heard seen much attention paid to the NCAA's fiduciary duty as it relates to its own members.
Interesting.
Yeah.
Speaking of challenges, let's see if 4 attorneys can get through the rest of this presentation in the next 9 minutes. So Jason, to you to give us an intro about student athletes as employees.
So just real briefly, because Tronda's got a point. We can talk, and there's a lot to talk about here. There's really 2 kind of categories here. So that we're going to talk about. One is the Fair Labor Standards Act, and whether under FLSA rules an athlete can be an employee of the university. And the other is for private institutions only under the National Labor Relations Act. Can an athlete be deemed an employee under that act? With respect to FLSA, I would just say that, and we'll talk about the case here, but there is a circuit split now, where as a matter of law, and I think it may be the 8th Circuit, but I could be wrong. Toronto might know.
I think it's the 7th and the 9th, so it's like everything but the 8th, but
in between there, that says as a matter of law, student athletes are not employees of their institutions, and that tees up where we're at with the current case that splits with that.
All right, Toronto challenge accepted. Here we go. Johnson. So plaintiffs in this case claiming that student athletes should be classified as employees and are entitled to minimum wage under FLSA, entitled to back pay, etc. The NCAA's defense there was athletic scholarships are compensation given to student athletes in exchange for time and services. I think, unfortunately, that is a losing argument, but essentially that is the very high-level backstory of Johnson. So District Court 2021 says no shot NCAA. Student athletes can be employees under the GLAT test, denied NCAA's motion to dismiss. GLAT test, it's a 7-factor test, really focusing on the relationship between athletics and academic education programs. And the closer that is, the more it weighs in favor of employment. But in 2024, just a couple months ago, 3rd Circuit says, okay, we agree that student athletes can be deemed employees under FLSA, but we don't like the GLAT test. So we think that that's an inappropriate test because athletics is not actually part of an education program like an internship is, and the economic realities test needs to be applied instead.
And why this is important is because as you look at those economic realities tests, they could apply to any school, division, whatever division, or NJCAA or NAIA, theoretically.
I think what's interesting, and trying to talk about this in a second, is the factors in the economic realities test are also really similar to the arguments that are made in the NLRB cases. So you're seeing the same types of arguments just being made in different venues. I'm sorry, Jeff, go ahead.
No, I was just going to say, I think it's important that what you both just said, because there's generally this focus on, well, the program's losing money, right? I mean, these athletic departments aren't generating any revenue at most of these institutions, and they're in fact losing money. So how could it possibly be employees based on that. Well, you can ask all sorts of business owners whose businesses fail, they still have to pay people.
I think that's a perfect segue into the concurrence in this case. The judge there also has similar questions, saying if you're going to apply the economic reality test, that's fine, but there's a glaring difference between your, Power 5, Power 4 revenue generating programs and everybody else. So some of the questions that he posed in the concurring decision are, are non-revenue sports part of the business? And are athletics actually incidental to university business purposes? Are they essential? Does a college really benefit from a revenue negative athletics program? Played women's tennis. We were revenue negative, just pulling money out the department. And how is the economic reality of a non-revenue student-athlete relationship, different from a musician, on a performing arts scholarship? So not necessarily a lot of answers, but, Jeff, to your point, a lot of questions that need to be answered, so that we can figure out what that, employee relationship is if one exists.
Yeah, coming up with the questions is the easy part, right?
Right. Do that all day.
That's right. We're good at that.
So we have about 4 minutes left to cover the rest of the presentation, so we probably won't have a chance to get to any of the questions that have come in. But with that, Christina mentioned kind of some of the factors showing up in the NLRB cases. So we have Dartmouth, where men's basketball student athletes were ultimately found to be employees because they provide a benefit to the university. So that came in the form of alumni engagement, increased financial donations, and just overall publicity for the program. And the university exercised a certain level of control, if you will, over the student athletes from, their practice hours, or care as it's known in the NCAA world, the rules that are in the student athlete handbook, as well as the travel schedules. And in exchange for that, although it wasn't directly compensation as some of us like to receive, they received compensation in the form of apparel, equipment, tickets, early reads for admission, some of those fringe benefits such as academic support, psych services, counseling, nutrition, you name it. So in March of this year, the Dartmouth men's basketball student athletes voted 13-2 to unionize, but Dartmouth decided that they were not going to hear that. So they appealed, and right now we're waiting for the NLRB's decision regarding whether they're going to hear Dartmouth's appeal. We have the University of Southern California. That case was filed in 2022 by an athlete advocacy group, National College Players Association. One of the things that really stood out to me is really challenging that interview rule, if you will, and just the idea that the NCAA and the conferences could be determined to be joint employers of the student athletes. So Notre Dame comes up again, unrelated to any athletic performance this past Saturday. And with that case, it's just from April of this year, the College Basketball Players Association filed an unfair labor practice charge against Notre Dame, asserting that the institution misclassified athletes as student athletes, if you will. So with that, I'm just going to highlight really quickly one of the resources that we're proud to be able to offer the member schools before I turn it over to Jason and Jeff for some final closing words. So with our NJCAA portal, we have a portal that we've created. This is just a screenshot of kind of the opening page, if you will. And in this portal, we have webinars that are housed. So past ones that we have put out there related to different topics, as well as some of our colleagues. So it's not just related to athletics, just higher ed practices in general. We have some documents or some resources that are available, as well as some information related to like declared compliance that some of you, again, with those multiple hats, you may have your hand in creating that report. There's also links to our website. There's the contact information from the different people that are on our team. And the way that you can gain access to this is when the email goes out, and it may be a separate email, if you just fill out the form, you will be able to receive access. And this is also mentioned on our portion of the risk management site that NJCAA has. So with that being said, I'm very proud of.
Can I just make a quick comment about that? I really want to make sure that everyone is aware that we're really, really excited about this portal. and we want to make it as vibrant and as useful as possible. So please share this information across your campus. Your partnership with us is not limited to athletics. There are so many different services that Husch Blackwell provides, as you heard me articulate those earlier. So if you want to be the campus hero the next time you're sitting in that cabinet meeting and there's someone in academic affairs or in facilities talking about some issue that they don't understand, remember, you have a membership within the NJCAA and who has a partnership, so by extension you do, with Husch Blackwell. They have services and attorneys and all sorts of functions that are available to assist you in the operations of your campus. So please think big in that regard and know that they're there to help.
Yeah, really appreciate that, Jeff, and we're excited to finally roll this this portal out, and it'll have information that's beyond college athletics, that is about a variety of issues facing institutions of higher education like yourself that we regularly assist with.
Perfect. So if anyone asked questions, we'll receive those. So we'll be able to follow up with you kind of individually via email. With that, I didn't know if you had any closing words. It's one-on-one, so I know at this point I've kind of gained a reputation for being like the referee when it comes to timing.
I will just say, so we do appreciate and thank everyone for joining us today. We appreciate Jeff joining us and kicking off this partnership, and we're hopefully that some of the information we provided was valuable. If you need more information, let us know. We are going to send a recording of this to you. That will be emailed along with information and a short survey. And we would just encourage you to provide some feedback on that survey so that we know what it would be valuable to offer you and your, your institutions in the future in terms of webinars and other information for you.
My
Jeff,
turn,
anything
right?
else for you?
Sure. Yeah. No, I thank you to the three of you for joining me today and having this conversation for the benefit of our membership and our association. Again, I know I just kind of went on a little bit of a monologue there about the virtues and benefits of our partnership with Husch Blackwell, but I do mean that sincerely. I know that each of you listening in today sit in multiple seats and face multiple challenges. The NJCAA, you get value in membership that goes beyond just the space of athletics. Know that we're here. We are diligently on top of these issues, making sure that we have a firm grasp and understanding of the implications of all these decisions, and that we're aligning with partners that are very plugged in, that are also staying on top of these issues to ensure that the NJCAA is staying out in front of these issues and not waiting to be told by courts and state legislators what to do. So again, thank you, everyone.
Thank you.
All right.